focus on rent regulation and transactions in the modern era. And we say modern era because you'll find out during this presentation that June 14th, 2019 was a doomsday for a lot of residential owners. Typical disclaimer, but for residential owners in New York City, the goal for them is to get fair market apartments. Fair market apartments allows residential owners more flexibility, more freedom of not having to comply with regulations set forth by the state. On the other hand, you have the New York State Legislature, who wants nothing more than to have rent regulated apartments for the most part, because then they get more voters, more affordable housing, more voters, and it looks good politically for them. In New York State, the New York State Division of Housing and Community Renewal is the government agency that is responsible for the administration of the New York State rent regulation and protection of the rent regulated tenants. And this is the agency that tenants can go and file various complaints that may or may not be occurring in their building. Just to give some background, rent regulation could basically be boiled down into two categories. One, rent control, which generally covers buildings that were constructed before 1947, provides certain protections to tenants, and they're considered statutory tenants. So that doesn't mean that you have to give them renewal leases. They just automatically renew. The second is rent stabilization, which generally covers buildings after 1947 and built before 1974, with 6 or more units, apartments removed from rent-controlled buildings, and certain buildings that are receiving certain tax benefits. Same as rent control, it affords tenants with particular protections. Today, we're going to talk about two methods that residential owners use to convert a rent-stabilized apartment to a fair market apartment. And this is, once again, all prior to June 14, 2019, and you'll see why. We have the high rent vacancy deregulation, and we had high rent, high income deregulation. So these are the two methods we're going to speak of today. Now, high rent vacancy deregulation is defined in 2520.11 of the Rent Stabilization Code. Basically, 2520.11 states that the code shall apply to any class or classes of housing accommodations except for, and then it lists a ton of housing accommodations that it doesn't apply to. For our purposes, I highlighted just briefly those certain provisions of the law of the Rent Stabilization Code that could be referred to. What does this all mean in that big legal context that I just showed you? It's applying lawful increases to an apartment's legal rent. If the legal rent meets or exceeds the deregulation threshold, the apartment could be deregulated and could be treated as a fair market subject to challenge. Now, examples of lawful increases included vacancy increases, longevity increases, and renewal increases. And once again, we are hit with vacancy increases and longevity increases being eliminated as of 6/14/2019. And in some instances prior to June 14, 2019, a newly created apartment could qualify for a high rent vacancy deregulation based on the circumstances. So to give you an example of a high rent vacancy deregulation prior to June 15, 2015 and 2019, the incoming tenant's legal rent met or exceeded the deregulation threshold for high rent vacancy deregulation. Then the unit was deregulated. An example would be if the deregulation threshold was $2,500, new tenant moves in and the legal rent for that apartment is increased to $2,900, the result is deregulated. Example 2, deregulation threshold is $2,500. The new tenant moves in and the legal rent for the apartment is $2,100. The result would be rent stabilized. Now, this is the way it was before June 15, 2015. Then comes June 15, 2015 and the Rent Act of 2015, which changes the legal community's view in regard to deregulation. Under the Rent Act of 2015, the predominant understanding in the legal community was that the threshold for high rent vacancy deregulation is tied to the vacating tenant's legal rent, rather than the legal rent that could be charged to the incoming tenant. So in our previous example, we were talking about the incoming tenant coming in. Now it has to be the vacating tenant's rent has to be above the legal deregulation threshold. In addition to that, the Rent Act of 2015 also increased the deregulation threshold from 2,500 to 2,700. And then thereafter, they would apply increases based on a yearly basis, which then, of course, changed in 2019. As you can see here, these were the historical deregulation threshold that were applicable prior to 2019. I wanted to just show everybody so that it was so they have an understanding of what the thresholds were during these years. Now, I'm going to provide two examples of the Rent Act of 2015 to demonstrate the interpretation of how the legal community was taking care of this. So if we have the vacating tenant's rent at 2,400, the deregulation threshold is 2,700, the new legal rent is 3,100, the apartment would be rent stabilized because the vacating tenant's rent was below 2,700. Example two, we have the vacating tenant's rent is 2,900 in this example. The deregulation threshold, 2,700, incoming tenant's rent, 3,100. Because the vacating tenant's rent was above the deregulation threshold, we would consider that deregulated, subject to challenge. Recently, there have been court interpretation that even after the enactment of the Rent Act of 2015, if the incoming tenant's legal rent met or exceeded the deregulation threshold for luxury deregulation, then the unit was deregulated. So essentially what this means is we go back to the first example with Blanche on it, where if the incoming tenant's rent met or exceeded the deregulation threshold, then it could be treated as fair market subject to challenge. Now, there are issues that could prevent deregulation despite the legal rent meeting or exceeding the deregulation threshold. One of them is active DHR rent reduction orders. Another one is each apartment circumstances. You have to take each apartment for what it is and not consider it just as a building wide, but more or less as an apartment wide. The second method that we were going to speak about is the high rent, high income deregulation, otherwise known as luxury deregulation. This is all prior to June 14, 2019. And this is the same law that we showed with the high rent vacancy, except this is Section S of 25-2011. And it basically goes into thresholds, income per the unit, and collective income of the occupants inside. Essentially, this all means luxury deregulation was an administrative proceeding commenced at DHR that resulted in the deregulation of a rent-regulated apartment under certain circumstances. Then 2019 comes and they dropped the boom. The legislature dropped the boom and they came out with the Housing Stability and Tenant Protection Act of 2019. It was passed. The effective date was June 14, 2019, and it took effect immediately. Among other regulations that are listed in the HSTPA, which you can feel free to call us and we can discuss, we're only going to be focused on the deregulation provision, which were repealed. And now that deregulation has been repealed, what now? And that's where we come into the modern era in regard to transactions. You should understand the past in order to be prepared now so you can protect the future. What does that mean? Review, analyze, understand, repeat. Now more than ever, due diligence reviews must be conducted. You have to assess your risk tolerance. What are your potential goals? If you're a potential purchaser, you analyze and understand what you are buying. As a reminder, you may be buying a building, but each apartment is its own issue. For sellers, you analyze and understand potential concerns. So when purchasers come and ask certain questions, you are fully prepared with the answers. Another one are lenders. They analyze and understand how the property is managed. And owners, they analyze and understand an apartment's history. So right now you should be reviewing, analyzing, understanding, and repeating each apartment's rental history. Now, I would like to just share a rent regulatory review hypothetical because I would like to demonstrate how this will work and the seriousness of not conducting a review. So a client retains you to handle the transaction of purchasing a 40-unit building in Manhattan that is being marketed as fully fair market. Sellers listing the property at $2 million. Client knows that the buildings in the area are going for $8 million. Client thinks that due to the economy, this is an offer they cannot refuse. Seller provides copies of the current leases for all 40 units. Now, all 40 units state that the units are fair market. The rent roll reflects the same. They're all fair market and have been treated as fair market since 2010. Although U.S. counsel stressed the importance of a rent regulatory review, client states that they do not want to spend more on unnecessary items. So the client and seller close on May 1st and title is transferred. The key thing to remember in regards to rent regulation is that when the purchaser obtains title, they technically step in the shoes of prior owner, meaning that the prior owner's liability is then transferred to the new owner. Come to find out after the transfer, a fair market tenant who has been in occupancy since 2011 files an overcharge complaint with DHCR. The tenant alleges that the apartment is rent stabilized and that they have been overcharged. Client reaches out to U.S. Transactional Counsel, and in abundance of caution, you reach out to Rent Regulatory Counsel, myself, Logan, who performs a review of the building and discovers the following. The records on file with DHR were not reviewed. If the records were reviewed, the docket report revealed that an order reducing rent was granted in 1990 for the apartment, and an order restoring rent has not been issued. Since this order is still active, it requires a reduction and freezing that rent, and such a directive would be a continuing obligation. Rent Regulatory Counsel advises that due to the rent reduction order, the apartment is not fair market and it is in fact rent stabilized. And due to the order reducing rent, now the HSDPA of 2019 precludes ownership from deregulating the apartment. It is advised that the frozen collectible rent for the apartment is $950 based on what was being charged back in 1990. Prior owner was collecting $4,000 for the past 6 years, treating it as fair market. Since the client stepped in the shoes of the prior owner, the client is not excused from this liability. Of course, the client's going to scream that they didn't know about the order. They weren't told about it. How can this happen? Basically, what happens next is the following. You tell the client, you heeded my words, not did you, as Yoda would say, and the complainant wins the case. DHA finds that a rent overcharge occurred and the tenant is entitled to $455,300. Appeals are filed and denied. As a result, this is a final order, and due to the HSDPA, the apartment is rent stabilized. Now, this has happened in several situations. Thereafter, because the tenants talk amongst themselves, they communicate with each other and discovered the same facts occurred with 5 other apartments in the building. Complaints are filed, and the same result occurs. Total refund amount is now $2,276,500, which is the same $450,300 per tenant. Without the rent regulatory review, this situation caused the client the following: incur over $2,731,800 in overcharge liability, which is $731,800 over the purchase price for the building. The rent roll may be negatively impacted because of what is going on. There is a decrease in the property's value because the building cannot be marketed in the future as a fully fair market building. And the client now incurred exorbitant legal fees that could have been avoided if a review was completed. So if you look at it, $731,000 in liability compared to much less just for performing a rent regulatory review can save a lot of potential liability. And we leave you with this: mind what you've learned, save you it can. Meaning that take the knowledge, try to understand the apartment's history and go from there and see how the apartment has potential liability. And that's the end of my presentation. I'm going to pass it over to Logan, who is going to share the second part of the presentation, and then we will address questions all together at the end. Diana, you're on mute.
While she's getting up her presentation, oh, my question disappeared. Hold on one second. I figured while she was getting up her presentation, I just had one question. Did you, now I'm getting a few. You know what? I'll wait till the end.
Can you see my screen?
Yep, we can see it.
We can
Just needs to be full screen.
Okay, great. Okay. So thanks, Sam. You did a great job of explaining the overview, you know, how these issues, prior issues can really trip up owners now, purchasers. You can just, if you're acquiring a new building and you don't do the due diligence, you can end up with an asset that you really know nothing about, and it becomes more of a liability than anything. So it's really important to know what you're buying and also to know what you're selling. So I'm going to talk about three main things: substantial rehabilitation exemption, apartment reconfiguration, and certifications of NLRS. So the sub-rehab exemption, which you may have heard of before, is the last method since the HSDPA was passed in 2019 to exempt a building from rent stabilization. The only exception would be if you have a building under loft law. But the last way available, since there's no more high rent luxury deregulation or high rent high income deregulation, is to perform a substantial rehabilitation. And so what does that mean? The current procedure to perform a substantial rehabilitation under the law is that the building must be in substandard deteriorated condition or 80% vacant. That's how the law reads right now. And substandard deteriorated condition, while DHCR does not necessarily define that standard, it really has to be such that the building is decrepit, you know, practically falling apart. It could be the extreme of the standard that DHCR would use. So if you have a building that's not in great condition, the next step would be to replace 75% of the building systems. All work, of course, must be DOB compliant. And of course, there can be no findings of harassment at the building. Certainly, you know, the decrepit condition of the building cannot be through any fault of the owner. It must, you know, has to be an old building that just hasn't been rehabilitated recently. So again, under the current law, once the rehabilitation is performed, right now, you can register the units as exempt unless there are any rent stabilized tenants still in occupancy. And if there are, then those tenants will remain rent stabilized until they vacate. And then you have a fully deregulated or exempt building. You can apply for a prior opinion from the DHCR to be sure that your planned work will be deemed an exemption, but you don't have to right now. There is a proposed bill right now that we're expecting to be passed soon, which will remove the 80% vacancy presumption. So in other words, under the current law, even if the building is not completely deteriorated, if it's 80% vacant, then that will satisfy that criteria for sub-rehab. We expect that 80% vacancy presumption to be removed. So you can't necessarily have a building that's in decent condition, but 80% vacant. That's not likely to comply once this bill is passed. So they're removing that presumption. And we also expect that once this bill is passed, DHCR will require owners to file a sub-rehab application, which again is not the requirement right now. You can, if you know, for a sale or refinancing, you can apply for an opinion if you need that guarantee, but right now it's not required. But we expect that an application will be required soon. So as I said, one of the criteria is that you have to completely replace and make as new 75% of the building-wide and apartment systems in order to qualify for this exemption. There's a DHER operational bulletin 95-2, which outlines exactly these 17 systems that DHER looks at, which I've listed here. Plumbing, heating, gas supply, electrical wiring, intercoms, windows, roof, elevators, incinerators or waste compactors, fire escapes, interior stairways, kitchens, bathrooms, floors, ceilings and wall surfaces, pointing or exterior surface repair as needed, and all doors and frames, including the replacement of non-fire rated items with fire rated ones. If you have a building that did not already have all 17 of these systems, then that item will not be included as part of the list, as part of DHCR's analysis if an analysis needs to be performed. So if the building has 15 of those systems, as long as 75% of those 15 systems are replaced and made as new, it will comply with this exemption requirements. You also have to replace all ceilings and floors in common areas and in the apartments. So what happens if you have a client or you personally own a building or looking to acquire a building or refinance a building that had a substantial rehabilitation performed in the past, and you need to be able to prove this exemption, the sub-rehab, in order to maintain the exemption. Also, if you get a challenge from a tenant at the DHCR, those are also instances where you may need to prove that a sub-rehab was performed. So just in this example, we assume that you are considering purchasing a building that was sub-rehabbed in the past. You want to, from the seller, request as much documentation of the sub-rehab as possible. This includes an itemized description of replacements and installations, copies of approved building plans, architects or general contractor statements, contracts were performed, government approvals, photographs of the conditions before, during, and after, invoices for the work performed, and proof of payment. This is just really important to note, because if it happened 20 years ago, it may be difficult to obtain these documents. So, these items are what's on DHCR's operational bulletin. So it's important to have all of these. And if you're possibly purchasing and the seller doesn't have these, this is really something to consider. It could greatly decrease the value of the asset. And of course, if you're in a situation like this and you want an analysis performed to see if a building either was properly sub-rehabbed in the past or is a good candidate for sub-rehab, that's the kind of analysis that Sam and I can do. All right, next, apartment reconfiguration. So prior to the HSTPA, prior to 2019, owners could reconfigure an apartment by either, combining 2 one-bedrooms to create a 2-bedroom, possibly splitting a 1-bed or 2-bed into 2 studios. Essentially, you would have to create an entirely new apartment, a new footprint. And as a result, because the new reconfigured apartment was considered a new apartment, you could set a first rent. The idea behind that is that the new reconfigured apartment is so different and unrecognizable in comparison to the old that the rent history of the old apartment is deemed irrelevant. So pre-HSTPA, you could set a first rent, and if the rent exceeded the deregulation threshold, you could deregulate the apartment by high rent vacancy deregulation. Post HSTPA, so after June 14th, 2019, you could still reconfigure an apartment in this manner and charge a first rent. So even if that rent, the new apartment was way above the prior legal rent, the apartment, you could charge a first rent, but the apartment would remain rent stabilized. So it's still a good option for increasing rent if that's your goal. However, there has been another bill proposed that we expect to be passed in the near future. So if that was a plan of yours or a client's plan to reconfigure, it's something to seriously consider because we do expect the law to change in the near future. So under the proposed bill, as an example, if you were to combine two rent stabilized apartments, so maybe 2 1-bedrooms or 2 studios to create a new 2-bedroom, instead of setting a first rent like you could in the past, the new rent would be equal to the combined legal rents of the 2 prior apartments, plus any applicable rent guidelines board increase for that year, and any IAI individual apartment improvement increase, which we didn't discuss, but as you may know, after the HSTPA is really no more than $89, around $89. So this is a significant change. Before, again, you could charge whatever the market would bear. Say you created a new 2-bedroom and the market would pay $4,500, that was the new rent. Now, if you take 2 1-bedrooms with a legal rent of $1,000 each, you combine them into a new 2-bed, the legal rent is going to be $2,000 plus the applicable RGB increase and any improvement increase. A strict reading of this proposed bill also suggests the same for combinations of free market units in buildings that would otherwise be subject to rent stabilization. So, for example, a building with 6 units or more that was built prior to 1974, even if the units were deregulated in the past, if you wanted to combine or reconfigure a free market unit in that apartment, again, a very strict reading of this bill suggests that that new unit would become rent stabilized, and the rent stabilized lease would be based on the prior. The rent stabilized rent would be based on the prior rent of the unit or units. We won't know for sure if that's how DHR and the courts will interpret this bill. We have to see, if and when it's passed and if it's challenged. But again, a very strict reading of the bill suggests that you could re-regulate free market units if you were to reconfigure them. Lastly, the same kind of goes if you were to, under this proposed bill, if you were to increase or decrease space in a vacant rent stabilized unit, even if it's not necessarily a reconfiguration, that increase or decrease in space would result in an increase or decrease in rent equal to the percentage of space that was increased or decreased. So they would take a percentage of the regulated rent and use that again. So it's not a first market rent in any way. Last, certifications of no harassment. There's so much that we can talk about this when it comes to this, but I just wanted to touch on it because if you are, owning, selling, managing a building that is either comprised of single room occupancy units or located in certain anti-harassment districts, you will need a certificate of no harassment in order to perform a sub-rehab or apartment reconfiguration. Specifically, the types of work that a CONH is required for would be full or partial demolition of a building, change of use or occupancy for all or part of a unit or any portion of a residential building, any alteration which removes or adds kitchens or bathrooms, any alteration which increases or decreases the number of dwelling units, any change in layout, configuration, or location of any portion of a dwelling unit, and an application for a new or amended certificate of occupancy. And in this brief discussion about CONHs, I'm not going to touch on pilot program lists applications for CONHs. That's a little bit different. Certainly, if you have questions about that, we could talk separately.
Before you get to the last slide, I'm just going to give everyone the code word for today. The code word is rent. The code word is rent. Thank you.
Thanks. So if you have a building or considering purchasing a building or selling a building or refinance a building that requires a CONH for any of that work, and you need to or want to do that work, you should know that it can be a long process. We typically, depending on how much information our client has for the building and how the building has been treated for the past few years, we generally estimate that it can take about a year to get a CONH, a year from filing of the application. But there are ways, if you need one, to make it go a little bit faster, especially if you have all of the information ready to go. So these are just a few examples of causes for delay that I've seen recently in obtaining a CONH. If you have a complicated corporate structure for the deed owner entity, this is not to say that I'm not giving any advice as to how you should structure your deed owning entity, but it's good to be able to clearly show HPD because these applications go to the HPD. It's good to be able to clearly show HPD what the structure is, who has authority to apply for a CONH, who has an interest in the deed owning entity. If you can be ready with that information, the process will go faster. Other delays, if you're missing tenant information, certainly you need information pertaining to current tenants of the building, when they commence occupancy, what their monthly rent is, whether their rent stabilized or not, whether they have a lease or not. But you also, depending on the application, you need at least 3 years prior worth of information regarding tenants that have vacated. So when they vacated, why they vacated, what were the circumstances. Certainly if it was a buyout, you need documentation of the buyout. You need an anti-harassment letter, which informs the tenant that they don't have a duty to accept a buyout or to vacate. And if the subject building is in an anti-harassment district, the inquiry period can be much longer than 3 years. So really the best way to expedite obtaining a CONH is to have all of this information ready and on hand. And then, of course, the last cause for a delay in obtaining a CONH would be if there are multiple HPD or DOB violations, especially hazardous violations against the building. And that is it for me.
Thank you, guys. Great presentation. I have quite a few questions. Just to remind everyone, I did type the code word in the chat so everyone has it in case they need it. So I'll start with the questions that we got. Can anybody speak? Oh, wait, where's the do lenders typically do the DHCR review or alternatively require the buyer to do so?
Generally speaking, yes. Especially more recently, lenders have taken into consideration due to the economy that a rent regulatory review should be part of the due diligence done before anything is going on. And I know, especially with the banking situation, we have clients who are lenders who have retained us just for the simple fact of reviewing the owner's documentation to make sure that they're operating the building properly.
Yeah, and just to add to that, it's not even necessarily on initial acquisition or project loan or building loan. We're seeing it now just on refinancing. So even if the lender had already issued a loan on a building, now, like Sam said, with everything that's going on with the banks, even on a refinance, lenders are often asking for a review that maybe wasn't conducted initially, and it causes problems.
Thank you. I did have a few questions about Section 8, specifically speaking on Section 8 rentals and whether a landlord can charge rent above legal rent if rented to a Section 8 tenant. Also, somebody asked if you can discuss if there's a carve out when Section 8 is paying a portion of the rent, and can the landlord change the market value when it's a Section 8 tenant?
There are The thing with Section 8 tenants is there are several different caveats. And in order to understand the situation, we need to know the circumstances behind it. So we can't just generally say X, Y, and Z until we know what's going on with the building and the Section 8.
Okay. Is there anywhere to get, where can we get full rent control or stabilized information during our due diligence? And do we need to file FOIA every time?
So to answer that question, basically where you would get that information from is the DHCR. And yes, in order to obtain that information, you would need authorization and file a FOIA request.
Okay. How long would it take to get an opinion from DHCR to provide an opinion if a sub-rehab plan would be approved?
It really depends if you have all of your documents in order. And it's hard to say. DHCR has been a bit backed up even since COVID, as have, many agencies. A conservative estimate would be a year. But if you have all your documents in order, it could be faster than that.
Okay. For some buildings that have new multiple dwelling tax exemption, would the rent stabilize automatically end once tax exemption expires, or does the owner need to file an application?
That comes down to this tax benefit being received. We would need to know what's being received. We would need to know dates. We would need to know apartment history, and then we can be able to form an opinion. But without the knowledge of knowing what a building is or is not receiving, we can't really generally just say this is the way it's going to be for X, Y, and Z.
Can an owner who lost deregulation in court sue the former owner for marketing the property as free market?
That we would have to look at the contract for, because I know that we've had clients who use our transactional attorneys where they had a caveat that if there was overcharge liability, there would be a certain escrow account where the prior owner would put money in. And if an overcharge happens within 2 years or 3 years after closing, then that money would be given to the new owner. But that's basically going down to transactional and what was in the contract.
Okay. Do you need a new building permit for substantial rehab?
I don't know. I mean, you certainly need permits. You need DOB permits for sub-rehab. And then if that person is referring to a certificate of occupancy, you would need a new certificate of occupancy if the sub-rehab changed the configuration.
Where do we find current rent increase thresholds online?
So with the Housing Stability and Tenant Protection Act of 2019, they repealed deregulation. So right there, after June 14th, there wasn't a threshold established. So the slide that I provided with the thresholds, the historical thresholds, would be sufficient to answer that question.
Okay. Do all the rules apply similarly in ETPA jurisdictions?
They are similar, depends on the circumstances. They pretty much almost mirror the rent stabilization regulations. So they would be very, very similar in how they're treated. Just one would be outside in the outside counties, one being in the 5 boroughs.
Okay. What is the current law regarding the limitations period for rent overcharges?
In regards to that, there's a 4-year look back, depending on the circumstances. As years progress, it is anticipated that it's going to go to 6 years. However, it depends on the overcharge circumstance. And whether or not the overcharge was willful, whether or not, or actually what caused the overcharge. Essentially, we would need to look at the rent ledger. If there's any active orders reducing rent, we would need to look at the tenant's lease history to make sure that the increases were appropriate, and we would go from there.
Okay, sounds good. I'm getting a bunch of Section 8 questions. This is the most questions I think we've ever got. So you guys are really, really engaging. Everyone enjoyed it. So we'll get to one or two more quick questions. You fielded the questions great because you never know what people are going to ask. So I'll get to one or two more questions before we end. And then if you have any specific questions, you can shoot me an email and I will try to get you the answers. In regards to Section 8 tenants, does the new private housing finance law, Section 610, preclude a landlord from accepting above the legal rent from Section 8? Does this only apply to HPD contracts?
That we would have to speak to you personally, because that's such a specific question that it could be perceived as legal advice. So we would recommend you giving us a call, explaining the situation, and then we can advise properly.
Okay. I'll ask one last question and then we'll wrap it up for today. If an owner in Westchester County has a Section 8 tenant, can the owner charge market rent on stabilized apartment if they do not have any agreement with the government agency?
We would need to review the regulatory agreements because there's sometimes certain provisions set forth in there. Unfortunately, the questions with regards to Section 8 tax exemptions and that type of benefit is very fact specific. So it comes down to actually reviewing the agreements or understanding the tax benefits a building's receiving.
Great. Thank you both so much for a wonderful presentation. And thank you everyone for coming. As a reminder, I will resend everyone the material and the affirmation along with the EC purchasing information in case you did not get it. Thanks again. And our next CLE, we will be taking a break for July. I know everyone's busy, but August 2nd, we will be having a CLE, which will be 1 credit on diversity. Thanks everyone again for coming.
Thank you all.